Thank you so much, Noreen. And thank you, Tunde, for that great intro to the world of ODR and how it is really coined as the fourth party within that spectrum that we all know of alternative dispute resolution. The spectrum itself, as Tunde has addressed, consists of various alternative dispute resolution mechanisms, which I will present on how one would navigate now from the traditional face-to-face alternative dispute resolution versus, as we're used to an online using that fourth element or the fourth party, the technology, the internet and the online platforms that we've heard come in from the previous speaker, Mr. Tunde. Now, from the discussions and prior to me presenting my slide, I needed to address a few questions that came up at the very end. For example, the issue of the legislations that are currently in play, for example, in my particular jurisdiction, which is Tanzania. Tanzania has advanced in pretty much a speed of light sort of effect in terms of putting in place legislative pieces or policies that are aimed to enhance or complement and embrace the fourth industrial revolution, that is the digitized economy. This is part of the agenda of the government that is currently in place. The sixth phase government has a strategy in place for the next 5 years that looks into the adaptation of technology and how it could be complemented by creating these enabling environments. So a good example is the digital transformation of our courts. We have a court-related ODR, a court-related online dispute resolution system that is basically offering the public a facing digital space whereby they would electronically be able to file in their disputes and manage their cases. So the judiciary, along with the legal fraternity, have had to really undergo an intensive training to ensure that these enactments, the e-filing regulations of 2018 to be specific, give effect to e-justice, electronic justice, by enabling cases to be done on that electronic platform. Now, even during the pandemic, we saw the uptake and the acceptance, which is the word that I would like to use, the acceptance of the usage of virtual courts within our jurisdiction. That acceptance rate really gave confidence, not only to the SMEs in the country, but also the big giant MNOs that are currently in play in the country. And just a few months ago, I think to just solidify on this point and the direction of the judiciary and the policies that are currently taking part and taking form in Tanzania, we saw the Honorable Chief Justice of Tanzania, Professor Ibrahim Juma, address a new recruit of advocates getting enrolled to the bar and telling them that this litigation route is not the only way. Look into alternatives, and specifically, here, as his address went on, online dispute resolution as a method to reducing the crowding in the courthouses. And so it really is a stage in our life. We can say that the transformation to the digital space is happening. I'm going to now present my slide. Oh, there you are. This is the button. Okay, I hope you can see my slide in front of you.
We can.
Thank you very much. And so before starting my presentation, what I wanted to comment on was a recent report by the E-Economy Africa 2020. This report should be very important to the SMEs that have dialed in today, because it speaks to the light of the fact that the digital economy is one that we cannot divert from, and how promising it is for entrepreneurs driving not only innovation, but also growing their businesses to take up technology. And that report was done in collaboration with two big giants, the IFC and Google. And what it said there, and it should be very interesting to the businesses, the analysis in that report finds that Africa's internet economy has the potential to reach 180 billion by 2025, accounting for 5.2% of the continent's GDP. By 2050, it says, the projected potential contribution could reach 712 billion, being 8.5% of the continent's GDP. And so the understanding that we are now learning on how we could navigate into the digital space and how we can handle disputes that may arise either from electronic commerce or even the face-to-face commerce that we're used to. All these kind of transactions, whether happening online or offline, will attract at some stage that remoteness that we can see even the judiciary come and take up. Now, we've heard definitions, we've looked into and understood the concept of ODR, and being that this is the fourth element in that ADR process, which is the technology. Now, what then kind of types of ODR are in place? This particular slide speaks of the synchronous and the asynchronous types of ODR. And ODR systems could either be asynchronous or synchronous, as it says there. And the communications online, if they're done asynchronously, as you can see there, valuable tools mediators would use in a synchronous communication would be as highlighted in that, such as video conferencing and instant chats, where there's that instantaneousness of communication. And so parties must be present for that particular communication to take place and be done effectively. However, in an asynchronous communication, you find that interaction is happening in intervals. So there's a discontinuous sort of manner of communication. And that is the format of an email exchange, for example. If you're negotiating a particular issue, then you'd have that exchange of email, and there will be a lapse of time between the next offer coming in onto your inbox. So asynchronous forms of communication is not conducted at the same time via the platforms such as email, and so therefore it is less direct. So I found that to be very important that we understand these two elements, or these two types of online dispute resolution. And as businesses or the lawyers that are representing businesses, these are formats that are embraced even in our national laws. We have Electronic Transactions Acts. The act enables you to conduct certain transactions or exchanges that can be conducted online. And so that is really where we can afford the issue of having to use online considerations. Now, in this slide, I wanted to touch on the reliance of technology when we come to an online dispute resolution. There's that heavy reliance on technology for parties to communicate. And as you go around it, and as you heard from the previous speaker, there's less control over the physical environment of the participants in that particular mechanism, be it a mediation. And we heard a question come about from the participants. How do you navigate from an offline to an online mediator? Now, with mediation, it is less of a formal process. That informality has made mediation really be sort of accommodative in an online environment. And online mediation is not new. It has been growing, and of course, growing at a rate that is exponential, as opposed to its counterpart, arbitration. You see, the formalities of the procedures in an arbitration are slightly more stringent, or there's that flexibility, but those procedural aspects have to be adhered to. And in a mediation, the informality of the process itself, and being that the media is facilitating negotiations between the parties to enable them to resolve their disputes, there's that element of slightly more control that can be achieved. And so therefore, it works very well in a mediation. And then, of course, you have no control over the party's environment. And I think my colleague touched on this as well, whereby you find maybe the environment or the setting that particular party is in is not conducive to having an effective ADR take part. And so you have that balance where the parties may have access to the technology, for example. They don't have access to the technology, or they do have access to the, or their levels of using that technology is not at par with the other party. And so all these issues need to be considered when you're shifting towards an online environment. One needs to consider, are the parties comfortable with usage of ICTs? Are the parties able to access the internet? And this really speaks to also the SMEs that I know are some located in rural areas. And in rural areas, you find that connectivity is not as high speed or secured as one would wish it to be. I have a particular client, it's an international NGO dealing with issues of refugees, and communicating with them, especially when they have an issue and they've registered an issue over our online portal, iResolve. It's really, really difficult. We have actually to follow it up and say, have you checked the system? We've sent it 5 minutes ago. Has it loaded to your end? So there's that lag of communication brought about by the accessibility. Now, certain reports by the UNICTAD and so on and so forth, and the International Telecommunication Unit, ITU, have looked into this issue of connectivity, and they've said, no, it's really not connectivity. Africa is well connected. The infrastructures are there. The problem is cost. The problem is cost of accessing that quality speed internet. So it's not the issue of infrastructure, because we all know in East Africa, mobile activities, especially when it comes to mobile money and the transactions that are coming off mobile money, have really, really created a mobile market, a mobile money market that is second to none in our particular region. And it's usually used to reflect the fact that the digital space and the use of mobile and other electronic means has been highly accepted in different areas. And so with less control in this slide, we would look at the issues of confidentiality. And we heard the question come in and the concern come in from participants with regards to the confidentiality and the risk of having a Zoom bombing or an eavesdropper, or even the confidentiality being hacked, the privileged information being shared between the parties for that particular process being hacked into and leaking, such as what had happened with the Panama Papers, for example. And there's that huge leak. And if there was privileged information, maybe intellectual property, highly confidential patents, then that would be already up in the public sphere, and that would defeat the purpose of an ADR. Confidentiality is one of the key principles that are embedded in an alternative dispute resolution, be it a mediation or an arbitration or so. Now, when I speak of confidentiality, and we heard the word trust come up, during the answer of Mr. Tunde. And trust is one of those top tier, top of the pyramid requirements for any ODR process to be used, applied, and accepted by the end users. The end users are the parties participating in a dispute resolution process along with their counsels and the entire network. And so these elements or these principles that have to be highly preserved were touched on by a very good scholar on online dispute resolution called Rifkin. He came up with 3 elements, and he said these were the essence of ODR. He spoke of trust, and then he spoke of convenience, and then he spoke of the fact that there has to be expertise in ensuring that parties are able to not only use the process, but they're supported by an expert who would be able to sort of come in and resolve any issue that will come about. And we'll see in my later slides. In this particular slide, I wanted to touch on virtual or remote hearings. And in virtual hearings or remote hearings or semi-remote hearings, there are some writers who are saying that virtual hearings or remote hearings are not the same as ODR. But as we heard from the speaker previous to us, they could all fall within the same sort of umbrella of ODR, because virtual hearings not being the same as ODR is that they're conducted using communication technologies simultaneously connected by the participants in more than one locations. And so therefore that particular element of that description fits into the ODR. Although online hearings could end up could create an overlap with online dispute resolution. So the same effect as of virtual hearings, that these concepts could confuse one when looking into a virtual hearing that is conducted by audio visuals, and whereas the case progresses through in the court process. And we find this in the Supreme Court of Victoria in a report that they, in Australia, in a report that they issued in 2020, that there's this sort of overlap between the online court and online dispute resolution in terms of the online or virtual hearing concepts. Then, I didn't hear this from the previous speaker, and so I should touch on it, on the fact that they could be hybrid processes, where you find yourself not purely online, so partially conducted online and then partially conducted offline. That is also possible. And we've seen this happen even in complex disputes where the parties may have agreed to proceed in an online format, and then only to find that the arbitrators find the need to hold a physical hearing, an in-person hearing, in order to satisfy themselves. Maybe they need a site visit, as Tunde said. And so there would fall into a semi-remote hearing where most of it was done online, and then they would fall back to the traditional means of having it done in a traditional way. So on my part, and I think I'm just halfway through my time, I find that it is very important that we touch on the processes itself, being that when we were creating the iResolve platform, we learned that there were these technical notes, the UNICITRO technical notes that are usually issued by the UN wing of trade. And these notes are not binding on service providers, but they provide some sort of guidance. And I heard through the pipeline that there is a formed panel to work further on online dispute resolution minimum standards. And I think they were sitting in New York maybe in a couple of days, at the end of this month. And the UNICITRO working group that is charged with this work would be sitting to come up with minimum standards, core standards for online dispute resolution providers, such as iResolve and the ones that were listed in Tunde's presentation, ODR proceedings, and ODR platforms. Now, these standards are very much needed in order for us to be able to now align and harmonize the ODR process. And so if we look at this process map, and this is where we talk about shifting now, because we spoke about, yes, there'll be an ADR clause. Yes, the parties would have initiated their arbitration or their mediation. And so how then does the ODR provider come into play? That is by lodging that dispute with the ODR provider, or the clause, and we're seeing this come to fruition. The clause itself could make reference to an ODR provider and usage of that ODR provider's processes or rules for a particular mechanism that falls under the ADR spectrum. What we can also see is with click wrap or smart contracts or browse wrap contracts, these are more technical terms in the ICT world, is that there are clauses that are embedded within these contracts that are done on the online world that provide for processes on how to resolve the dispute. So you may find, for example, if you're purchasing something online, maybe through the Amazon portal, the Amazon commerce market, you find that if you raise a complaint and that complaint is assessed and then they refund you your money, that is an ODR process. If you are ordering an Uber and you get ripped off, and it has happened to me several times, in terms of the driver then, does his thing and the fare comes up to be a very unfair fare, and you lodge a complaint to Uber, and Uber returns with you sending either proof that you made payment in excess of what was assessed when you were calling the Uber, when you were ordering your Uber, then you would say, I've paid this chap over the amount by $30. Uber will then refund you by way of tokens, I think they call them. It's a token or a balance, which you can then use in your future trips. That is a form of ODR. Now, when you're involving an ODR provider that is separate from these already automated processes or already processes that have already got a system that deals and manages these complaints in an online environment, then you can be able to use and engage an ODR provider. If we look at the process map, you start by lodging, then the appointment of a specialist, somebody who sort of looks into the particular elements of that case and ensures that yes, it is following the right route, and then appoints, or if it's going to be appointing a neutral within the ODR provider system, then it will do so, or provide a response to provide a notification to the respondent to elect, maybe select or confirm the neutral that has been elected by the other party. And then, of course, it goes on and on with the processes to be followed. If it's an arbitration, then it's the filing of statements of claim and so on and so forth, the pleadings, and then that will go in through an automized system. And the ODR provider's role is really like an institutional role when it comes to an institutional mediation or an arbitration, where it provides the support on an online platform. The technology used provides the management of the process, but ensures that it lives up to the principles and the procedures set in the traditional form of ADR. You see, so that's where the catch. ADR principles live on even in the online environment. Now, this is how iResolve was crafted. So we have the ODR platform, we have the tech support, we have the online arbitrators, and then we have the third-party providers, and then the administrator, such as that has been provided for definition under the ODR technical notes of the UNICITRAL. And the ODR administrator is tagged to be an entity that carries out such administration and coordination, whereas the ODR platform is the system for generating, sending, receiving, storage, exchange, or otherwise processing that communication in a manner that ensures data security. So the catch there is that that platform would have to be secured. So with that catchphrase coming in from technical note 26, ODR platforms have had to have a secure portal where it is encrypted. And you find that most of these cases, if they do proceed in an ODR form, they would be highly, they would use virtual platforms or such as WebEx that is highly encrypted in order to secure the information and prevent any leakages of information. Now, when you're preparing for this remoteness, and I'm just about to start wrapping up, the nature of the dispute is something that one needs to consider. Parties' capacity levels to utilize the tech, as I said earlier, secured consent and informed participation. These are two elements that work hand in hand. Without that consent to utilize these remote mechanisms, then that would really defeat the purpose of having to ensure that those parties are participating. Enabling environment, we spoke of the national laws, enabling provisions in the law to allow for electronic signatures. We heard about the question on electronic signatures earlier, and I think I noted down a comment that I wanted to highlight in terms of electronic signatures. Yes, in Tanzania, we have electronic signature laws, and we have a particular act, the Electronic Transactions Act, that provides for the features, the key features that authenticate the electronic signing, meaning that it has to be somehow from the original form and not pasted onto. That would not equate to a properly signed document. And you find yourself usually being sent back from the different authorities when you have a document trying to maybe register a mortgage, and they tell you, oh, that signature is not from an original signature. And you try to argue your point that my client is in China, but it wouldn't go your way. It has to be aligned to the features that are contained in our national laws and done so, or in secured platforms such as DocuSign and encrypted or marked with that signature encryption that usually authenticates it. Consider the institutional rules. So it really depends on that ADR clause. You come back to the institutional rules. Most of the institutional rules have allowed for virtual hearings. And we've heard that we have had protocols highly acceptable, such as the African Arbitration Academy protocol. And these rules and protocols and guidelines are complementing and should be all considered in terms of you preparing yourself to go remote. Being a tech savvy neutral, this is a complex one. And it really does eat away a good mediator if they're not tech savvy. You may be a good mediator. You may end up agreeing to a mediation being conducted online, but then that technology could tarnish that process altogether if you're not either prepared or tech savvy, especially in dealing with situations where you would not have expected to have. Adapting those protocols, as I mentioned earlier, is also a key element. When you're considering now the technology, who would select this technology? You're shifting now from the traditional to the online. who is to select? It is the parties. Remember, ADR is a purely consensual process, be it a mediation, an arbitration, an adjudication, or so. It has to have that consensual aspect of things. And so even when you're agreeing to a formality, such as going online, then that has to be by consent of the other party. And so you would probably agree to a particular technology by consensus, or by default, the tribunal would do so on your behalf if you fail to do so. Some of the elements that one would have to consider, as my last bullet point says there, is the cost. And what is the impact of going online? What is the cost impact? And so using free versions of Zoom, as we heard from Tunde, it is very, very risky. But some have been able to do it and perform online processes successfully without being hacked into. But having the sophisticated options available to the parties could also hinder those risks and be more convenient and efficient for tribunals or mediation sessions. You have to also look into the technology. Does it provide for the elements that you need, or the issues that might come up that you need, such as usage of breakouts? If the mediator plans to have caucuses, then that particular platform or technology being used should provide for a caucus option, meaning breakout rooms. For example, at this point in time, iResolve cannot provide breakout rooms. And so we probably shift to another provider where one can have a breakout room to use. And of course, these protocols that I mentioned do provide certain guidance on how these breakout rooms could be utilized. Now, the participants' technical abilities, we spoke about data security and confidentiality, we spoke about, and of course, the uninterrupted high-speed internet and so on are also captured. Ease reference of documents. Now, this is a very problematic shift from the traditional advocacy skills that we have. A virtual advocate, as a lawyer, a virtual advocate faces an array of difficulties because of being unable to navigate through the documents, especially when you have a witness who's located in Tokyo and you, the counsel, located in Dar es Salaam, and you're trying to tell that witness, refer to this certain document, and the document is exhibited in front of screens, and that document is not the same document being projected in front of the screen in Tokyo, maybe. So if there's no synchronization, it could really, really destroy your cross-examination. It could destroy your virtual advocacy skills. And so what we say to virtual advocates, if you're a lawyer going to represent a party in a virtual proceeding, you ensure that you practice, you know your exhibits, you've tagged your exhibits correctly so that you can make reference to your exhibits. If need be, have a practice session with the person providing document, they're called document production portals, whereby they usually use some sort of software to project so that the tribunal is able to see the documentation, the tribunal is able to also see the transcript if it's automated transcripts, and then also able to see the screen of the particular witness and the counsel. And so the difficulties there could be worked into. I'm just wrapping up now. The technical disruptions and backup plans are highly encouraged. Of course, we have the guidance. We do have the African Arbitration Academy protocol on our virtual arbitrations, but we also have other guidances from well-renowned institutions, such as ICC guidance note on measures to be taken for purposes of COVID-19. And then, of course, they came up with also the information technology guidance that came out earlier this year or late last year. The SOL protocol is one of the oldest ones, and it does really provide for a really in-depth way of managing technical disruptions. And of course, the CPR, annotated procedural order. PO stands for procedural order. And this order I find to be very, very informative, because it now gives you the look on the other side of things. How then do we propose to the arbitrator how to go on the procedural aspects of things for a particular arbitration? Now, we've spoken about the logistics. We've spoken about the hardware. You need hardware in order for you to transition from the ADR to the ODR. You need the hardware. Location for the virtual hearings, if it's a virtual hearing, all this needs to be considered. And of course, the internet, as already discussed. Strategizing, and I think this will be touched on more on the legal issues when Laura comes up. You need to have had that strategy in place. You identify the issues that might come up in that particular case. Eliminating oral hearings if need be. We heard from Tunda, there's a documents-only procedure. The WIPO, for example, when dealing with domain name disputes online, it's purely done online. And that works very well. And it's a very good example of just a pure online process with only documents and a decision being rendered within a particular timeline. Parties' rights to be observed. Natural justice principles must be observed, because you do not want to come at the end of the process where the award has been issued and then there's challenges as to the parties' rights of equal treatment had not been observed as a result of the use of technology. So they have to be well managed. Limiting it to the evidence that is needed. So I've seen a particular matter being dealt with whereby we had to limit the kind of evidence and only use the evidences that were going to be used for the hearing, as opposed to having the entire bundle, especially in a construction dispute, as we heard, where it's heavily documented. And it's really doesn't work in a virtual setting. And then, of course, having that innovative application of things. I like this one because innovation creates these new arenas for one to dive into if they've identified issues that need to be handled at a faster pace. And so that is my presentation. Africa, what Africa needs now, if I speak continent-wide, is greater, more stronger digital governance. We need codes of ethics, we need regulations, we need data protection laws. In Tanzania at this moment in time, we do not have a data protection law. And because we have a strategy, as I initially presented, we have a strategy to go into 4IR, the fourth industrial revolution, without having data protection laws in place. And with big data demanding more and more, the legal space will be really crippled if we do not have this done in light of either including it in our telecommunications laws or at least instilling it as a way of a regulation in other spaces to include this data protection and ensure there's privacy, there's confidentiality being observed, and at the end game have that trust built because of the fact that it is regulated and the parties feel safe enough and confident enough to trust the process in an online platform. So allow me to end there. I think I've spent slightly over the time, but I beg to cure it during this question and answer time. Thank you.
Thank you, Madeline, for your very informative interventions. You've discussed, the prevalence of ODR, including what the Tanzanian government is doing towards that. You even talked about the process for ODR from beginning to end. We talked about considerations that parties must have, the logistics, and then you went on to even urge the continent and the different jurisdictions to pass laws that will support ODR. Thank you. And there are a couple of questions, of course, some of the questions you touched on already in your presentation, but there is a few that you haven't. And I think one of the ones that came in was by Mary, and she was asking about equality of arms. What happens when one party is tech savvy and the other is not? How do you ensure that there's sort of equality of arms when it comes to ODR?
Thank you. And I think that's a great question. And it's something that we're facing a lot, especially with the small claims that we end up using online platforms to deal with. And you do find, I tend to find not only the parties, but also the other members of the ADR process, be it if a co-mediator or a co-arbitrator. And so the solution, and I hear this being echoed in various scholars' writings, is practice. Prior to that actual setup of the mediation session, ensure that the participants are able to use the technology that has been elected. And so practice and ensure that is so. If you end up as an arbitrator, for example, identifying that one of the disputants or one of the parties or one of the lawyers representing a party is unable to navigate through the technology. And I would, if I was that arbitrator, I would have to propose for a physical setting so that we could have that equality of arms as the question has been posed.
Thank you, Madeline. There's a question here about how do you deal with disputes when the parties are in different jurisdictions and they have different laws? How do you deal with that kind of ODR dispute?
Well, now, usually we would fall back to the contractual governing laws if it's a contract-based dispute. If it's an online-based dispute, we're all cognizant of the fact that the internet is a borderless sphere. And so the questions of what law should apply is an interesting one. And it has been observed by various jurisdictions in a different light in terms of now, do we apply the law of where the server is? Or do we apply the law of where the ODR provider is? Or do we apply the law of where the parties are sitting? So, there's been mixed feelings. And so therefore, it will really depend on the circumstances and the setup of that particular dispute as to resolve the issue of the applicable law or the governing law, or if it's an arbitration, the various choices of law of the parties.
Great. And speaking of ODR providers, there are a couple of questions concerning them. There's one particular one that's directly about Tanzania, asking, whether the government has any preference in terms of ODR providers or regulated ODR providers in Tanzania.
That's an interesting conversation. For now, it's an acceptable form of means of resolving disputes. There is no law that prohibits it. If I say prohibition, that is, for example, cryptocurrencies. The central bank in November 2021, I think, issued a circular saying that cryptocurrencies are not legal ledgers. That is a prohibition. But in terms of ODR, there has not been any issuance of law or to the effect informing us that it is not acceptable under our laws. Not only that, currently, iResolve has been approved as a provider of the dispute resolution process for domain names ending with .tz, the country level domain name. And so that shows the acceptance rate in terms of the authority, the Tanzania Regulatory Authority for Communications, having that confidence in the fact that these are domain name disputes, purely online based, and therefore, why not iResolve being able to do the same. And so rules will be formulated, and that supplemental rule will guide the process of resolution of those domain name disputes. I wanted to add something, but it just went out of my focal point.
No problem, Madeline. And just following up on the ODR provider's question, someone asked, how do you ensure that the ODR provider is independent? What can you do to confirm the independence of the ODR provider?
That's really interesting. The ODR provider has to remain independent, and I think this comes about from the engagement at the very onset. The ODR providers that are currently in play, if you read their rules, you would find that they have provisions of maintaining that neutrality and maintaining the confidence of the parties by having a confidentiality clause, and also observing the ethical principles around the issue of ODR. These ethical principles have been, because ODR is self-regulated at this point in time. Even when the UNICTAD first sat and drafted these technical notes that I'm referring to, their view was that if we regulate, we're going to narrow the application. And because technology is ever so evolving in such a fast pace, self-regulation is much more conducive to such an environment. So they've set back in terms of regulating this space. But ethical principles were then developed. And as I said, in March, end of March, they're thinking of creating minimum standards for players within the ODR field. Minimum standards, mind you, not regulations, not model laws. Yeah, because if they wanted regulation, then a model law would come into effect, but not that way. Now, if we look at the ABA, the American Bar Association.
Sorry, Madeline, I think we lost you for a couple of minutes.
Yes, sorry.
You're back now.
I think it was an incoming call, that's why. Apologies. They've captured in a commission report of 2020 the ethical principles behind ODR. But what I would want to direct most of our participants today is a paper by somebody called Wing. And if I can get the name very quickly, it's someone called Wing. And she wrote very well on these ethical principles, naming accessibility, as we heard from Rifkin, accountability. The ODR provider has to be accountable for what they're performing on their portal. Competency, the expertise aspect that Rifkin also captured in his model, in his pyramid. Confidentiality, of course, we've spoken about. Equal treatment of the parties, that we've spoken about. Being neutral, you've highlighted that in your question. Secure and transparency. And transparency is an issue also picked on in the technical notes that guide ODR providers and provide for some sort of direction. But we're yet to see how this other working group that has been formulated late last year in Japan, how they would work towards creating these minimum core standards that processes, ODR processes, providers, and players can utilize to make sure that we are all harmonized in terms of what is acceptable and legal.
Thanks. Madeline, there's a question here from Nan Chang Nang Wang, and they're asking, is there a requirement for someone who's an ADR practitioner to fulfill before they can become an ODR practitioner?
Well, the name is difficult, and the question is even more difficult. But why is it difficult? It's because we have not seen any issuance of competency qualifications for ODR practitioners. This particular field or area, yes, it has been developing since the 90s, where I think we've had several phases of development of ODR generally. And these phases coming from the 90s, where the eBay concept, we've seen the talk of eBay and Colin Rule coming about with eBay. Okay, yes, how do we then resolve problems arising in eBay platform? Oh, there it is, let's do it online. From then on, we have not seen a lot develop in the space. But there's a lot of scholars that have proposed for a means of putting competency qualifying sort of measures, whereby we have persons who are equipped to do the work, doing the work of ODR.
Great. There's still a couple of questions. There's someone who is asking, I think Hussein Nicolene, who is asking, what happens when the parties speak different languages? How does the ODR process protect parties who have, or cater for parties who speak different languages?
Great question, and I think that is a problem that also comes about in the traditional ADR. So what would happen would be an e-translator would be involved, be it an e-software that translates automatically, such as that of a transcript, where you need the record to be recorded. There is an electronic means to do that, and I think, you know, I was very impressed. There's a hearing that I did, and we had a stenographer do the transcription online. And so that was very interesting. It was there, it was instantaneous, it did not miss a word. Now, the same way with the translator would be in an online setting, where you would have them either present for purposes of translating, or fully automated if it is a system that can capture the words and automatically translate.
There is two final questions I think I'll ask you before we move to Laura. There's a question here about protecting the ODR process from forgery and fraud. What can parties do, or ODR providers do, to just protect the ODR process from those interferences?
Interesting. This is a very crucial question. Why I say it is crucial? Because of the fear around cyber security. We do have, for example, in our country, the cybercrimes legislation of 2015, and that does provide some avenue of one to start off on the national law. Now, with an ODR provider, what efforts can it make? And this is something that I had to do a lot of research on, along with the technical team that I have in place to assist me. That technical team had to seek out certifications for the platform to be secure. So those certifications, I think this is more ICT wording, but those certifications, SSL, secured security, I think, something, those are available. Now, to what level do you achieve that encrypted security is up to the platform itself. And there not only that, but also having the case managers constantly being able to manage the documentation that is stored in the platform or the portal. That, I think, is also efforts in terms of using now the human resource to ensure that there is nothing that is hacked into, because this is how the ICT world works. They usually constantly monitor, that's the word, monitor everything that goes on the system, goes around and happens on the system. I think that those are the two ways that we minimize the risk of confidentiality breaches, of cyber acts against anything that is on the portal.
Thanks, Madeline. You mentioned that, you know, ANSI-TROL, there's a commission from ANSI-TROL that is still coming up with minimum standards to sort of assist or guide the ODR process. But a lot of panelists seem to be curious about, you know, what can they use in the meanwhile? What, whether it's guidance notes or model laws or standards or guidelines they can use to just assist them with the ODR process in the meanwhile.
That's it's a good, excellent last question. As indicated in my presentation, I think what is currently in use are really efforts by private players in the market. And these private players I speak of are institutions such as maybe the ICC, coming up with guidelines that assist parties, or protocols and notes that assist parties in virtual settings. We've seen the African Arbitration Academy also do the work of these private efforts to ensure that we have at least something to fall back on in terms of how to go about the process, be it an online mediation, an e-arbitration, or adjudication highly done by documents only process. And so there are several guides, protocols. I've seen rules being adapted recently by institutions to support the virtual arbitration, or it's a virtual mediation. Institutions are now starting to put in place rules, and these procedural rules should be looked into prior to you shifting to the ODR mechanism of choice.